I've taken the bar exam 14 times, and basically that's what's happened to my hair. And I want to make sure you keep your hair and you pass the bar this time. So let's get back to the job at hand here. How do I even know torts is being tested in a question? Well, somebody would bring a cause of action. You bring a cause of action in a torts question, that's how you know it's testing torts and not criminal law. If you're given a correct criminal law answer, let's say the defendant lacked the requisite mens rea, the term mens rea is used in criminal law. If the question asks to bring a cause of action in the question, that indicates torts is being tested. So the criminal law response that would be correct as covered in criminal law is not the right answer to that particular question on the multi-state. Also, correct statements of law are better than correct statements of fact when you arguably get it down to two correct answers. And I'd like you to approach the questions, whether it be torts or anything, by process of elimination, because you're trying to eliminate the incorrect answers to get it down to the best of the given alternatives. Many times you'll get it down to two arguably correct answers, and sometimes it's phrased in the what's called the double negative. No, you can't recover unless this. But that's not how you and I speak. We speak yes if this. So I want you to convert when you see no unless in an answer choice to yes if, and that's how we speak, and you won't be fooled by what's being asked. Also, negligence being duty, breach of duty, proximately causing injury or harm. If you are given all four of those answer choices in a negligence question, you want to choose what we call pick an answer that's higher up in the negligence ladder to negate negligence. In other words, if there's no duty owed, that's the first thing we're looking at, then we don't have to worry about breach of duty or proximately caused injury, because it's higher up in the negligence ladder. It would be the best of the given alternatives. I hope those testing skills are helpful in addition to the knowledge of the law. Also, there's used on the multi-state bar exam is pure comparative negligence unless you are told otherwise. So you wouldn't use contributory negligence unless the question asked for contributory negligence. Now, what happens in a pure comparative negligence jurisdiction? There's a two-part formula. You find out the party's percentage of fault, and then you reduce their recovery by it. So let's say I'm suing you, and I want $100,000.
Good luck.
And it says that 30% of the damages was my fault. Well, what's 30% of $100,000? It's $30,000, and you can't recover your own fault. So $100,000 is what I want, minus my fault of $30,000 or 30%, and I would recover $70,000 in a pure comparative negligence jurisdiction. In a modified comparative negligence jurisdiction, that's when the plaintiff is 51% at fault or greater, then they recover nothing. In a contributory negligence jurisdiction, if the plaintiff is 1% at fault, they're denied recovery, they don't get anything. You don't use contributory negligence unless you're asked to use it on the multi-state bar exam. And why I'm talking about negligence for the essays, the basic approach to any essay is your IRAC approach. The I for issue, R for rule, A for analysis, and conclusion. The issue is, did Kenny commit the tort of negligence? The rule is that negligence is breach of duty proximately causing injury or harm. In the facts I was given, the analysis and the facts I was given to work with, there was no breach of duty, cutting off negligence at that point. My conclusion is Kenny is not liable for negligence. I then skip a line, I go to the next paragraph and address the next issue in the essay, staying organized. Now, where do we want to go from here? Also, you have Judge Cardozo's approach that you only owe a duty to a foreseeable plaintiff within a zone of danger. That's the majority view. If you want to know the minority view, it's Judge Andrews' approach, which was a duty is owed to everybody. It's the hindsight approach. That's not what we go with to answer it, because that's the minority approach. We want to go with the majority view. You need a foreseeable plaintiff with inside the zone of danger, if you remember the Paulsgrave case from law school. Now, there's also particular standards of care or conduct depending on who's being sued. And when you're dealing with professionals, specialists will be held to a higher degree of care That's the national standard when you're dealing with professionals, let's say doctors. Children are held liable to the standard of care of a child of age, intelligence, and experience. It's called a subjective test. Children engaged in adult activities may be required to conform to adult standard of care. So you want to know that dealing with whether it breached or not to hold someone liable. You have the attractive nuisance doctrine under the category of negligence. And with the attractive nuisance doctrine, you are dealing with an artificial condition on property that injures a child. So if you see that in the facts, a child getting injured by an artificial condition on the property, most courts impose on the landowner a duty to exercise ordinary care to avoid reasonable foreseeable risk of harm to children caused by an artificial condition. That's called the attractive nuisance doctrine, and that's how you know that's being tested, and you bring up the rules that you were taught in bar review and law school and from this lecture. Now then you have to classify the person who's injured. You're either a trespasser, a known trespasser, a licensee, or an invitee. And what duty of care is owed to a trespasser that just comes on your property that you don't know they're there? No duty of care is owed to a trespasser. But what duty of care is owed to a known trespasser? The duty to warn of known dangerous artificial conditions. That's for an anticipated trespasser. Now, you also have something called a licensee. And what duty of care is owed to a licensee? The duty to warn and make safe known conditions and non-obvious dangerous artificial conditions. The licensee is someone who comes onto the land of another with their permission for their own purpose, and that's an invitee. And you have members of the public, they're called business invitees. Now, then you have a duty, land held open to the public is like you go to a museum and this property is for the purpose connected with the business of the landowner, like a museum, you are classified as an invitee where you have to inspect and make safe. So you want to know how to classify the person. You have violations of statutes. If you're given a statute in the facts, the odds are that's going to be tested, so you want to read it carefully when you get to it. Don't take out your highlighter and make it a coloring book or your computer and turn it into everything underlined. Only underline stuff that's important. You can see I have my highlighter with me. It follows me around. Now, when you have violation of a statute, you're being tested on negligence per se, meaning the person's conduct is automatically treated as negligent. The plaintiff has to be the part of the general class of people the statute was designed to protect, and the plaintiff's injury was within the general type of harm that the statute was designed to prevent. So when negligence per se is being tested, and you bring it up when there's a violation of a statute. There's the concept of res ipsa loquitur. Res ipsa loquitur is a Latin term. A lot of the law comes from Latin. It means that thing speaks for itself. And I want you to know that it shows an inference of negligence. Make sure you don't say it imposes liability for negligence. It just shows an inference of negligence. It's circumstantial evidence of negligence arises where the accident is one that normally doesn't occur in the absence of someone being negligent. 2, the instrumentality causing the injury is under the defendant's exclusive control. And 3, the plaintiff must introduce evidence removing any inference of their own fault. In other words, they have to show no contributory negligence on the part of the plaintiff. Questions testing res ipsa loquitur often have the defendant making a motion for a directed verdict. So don't be surprised to see that. That's not testing civil procedure, it's testing tort law. And where res ipsa loquitur is established, the plaintiff has made a prima facie case and no directed verdict may be given for the defendant. In a motion asking for the court to issue a directed verdict, the motion is made before a case is submitted to the jury and argues that no reasonable jury could find for the opposing party. Now, whatever evidence exists for such a ruling is legally insufficient. The case is taken out of the hands of the jury by the judge. So that's what a motion for a directed verdict would be. Now, the questions testing res ipsa loquitur is not just memorizing, but understanding it, is that the testing res ipsa often has the defendant making, as I said, a motion for a directed verdict. Now, a directed verdict would be either granted or denied. and it will be granted if the defendant's motion has failed to establish res ipsa loquitur and failed to present some other evidence of a breach of duty. The motion for a directed verdict would be granted. On the other hand, a motion would be denied if the defendant's motion for a directed verdict, if the plaintiff has established res ipsa loquitur or presented some other evidence of a breach of duty, such as the defendant's violation of a statute, they would deny the motion for a directed verdict, the judge. There's also, you're covering a lot of information in a short amount of time to give a general idea of the topic of torts, and we're talking about negligence right now. So really you have what are called independent intervening causes. I know I seem like I'm speaking some foreign language, but I'm not. I'm speaking tort law. Independent intervening forces or negligent acts of third parties, acts of God, intentional torts of third parties, and intervening forces that produce unforeseeable results are generally deemed unforeseeable and called superseding causes. And they break the causal connection between the defendant's initial negligent act and the plaintiff's injury, thus relieving the defendant of liability. And then you have to show damages as an essential element of negligence. Thus, damage will not be presumed. Nominal damages, where you see $1, is not available. What if you have just emotional injury? Recoverable only if there's some accompanying physical injury, and pure economic injury is not protected by negligence causes of action. Then you have the areas of, is it in contribution versus indemnification? Fine line, Hornbook and restatement distinctions being tested back and forth, back and forth. Now, contribution, the definition of contribution is allocation of loss amongst joint tortfeasors. So allocation of loss amongst joint tortfeasors is contribution, and indemnification shifts the loss to the party who is 100% at fault. So don't be tricked between indemnification and contribution. That would cover an overview of negligence. So we're moving into another category of tort law called strict liability. And there are three broad ways that strict liability is tested. One is 402A of the Restatement of Torts that I'd like you to try to memorize to the best of your ability because it's highly tested on the exam. And claims arising from abnormally dangerous activities like blasting operations would impose strict liability. You would stay away from the foreseeability breach of duty answer because that's negligence, and this would be testing strict liability. And also claims for wild animals or animals of a dangerous propensity. So you have animals of a dangerous propensity or wild animals, abnormally dangerous activity like blasting. Strict products liability under 402A of the Restatement of Torts is important, and the defense to strict liability is assumption of the risk, where you voluntarily assume a known risk. It's never contributory negligence. Contributory negligence is never a defense to strict liability. The defense is called assumption of the risk, where you voluntarily assume a known risk. Now let's just talk for a minute about 402A strict products liability. It's very important, and they will test the fine line Hornbook and restatement distinctions. The Hornbook for torts is the Prosser Hornbook on torts. If you've never heard of it, you do now. And strict products liability is where one sells a product, keyword, in a defective condition. The word defective condition is indicating strict liability being tested under 402A, not negligence. So one who sells any product in a defective condition, unreasonably dangerous to the user or consumer or their property, is subject to strict liability for physical harm caused by the ultimate user or consumer. Bystanders can also sue under 402A because there's no privity of contract requirement. You don't have to be the person who purchased the car, purchased the product. If the ultimate user or consumer that's injured can sue under 402A when a product leaves a manufacturer's hands in a defective condition, unreasonably dangerous to the ultimate user or consumer. You're dealing with 402A strict products liability, and you're not being tested on negligence. Once the product leaves the manufacturer's hands in a defective condition, everyone down the line of commerce is held strictly liable. That includes the retailer selling you the product. Now, what about an occasional seller? Let's say I want to sell you my car and you're driving down the block and the steering wheel falls off. Can you sue me under 402A strict products liability? No, because I'm not regularly engaged in the business of selling a product. I'm an occasional seller, so you'd have to sue me for negligence if I was, or you can't go for the strict liability answer, even though it would look good. Your defenses to strict liability, strict products liability, are assumption of the risk when you voluntarily assume a known risk, or you misuse the product. Privity, as I indicated, is not required. The ultimate user or consumer or bystanders even can sue. That would be for strict products. Make sure you spend some time on that. It's very important. And remember that everyone down the line of commerce is held strictly liable when the product leaves the manufacturer's hands in a defective condition, including the retailer that sells you the product. Dynamite, you see dynamite being used in the facts. You see crop dusting. You see those are abnormally dangerous for strict liability to apply. But they must have resulted from one of the dangers that justified the classification of the activity as dangerous to begin with. So dynamiting, crop dusting, exterminating are examples of strict liability under abnormally dangerous activities. And don't get it confused with the negligence response. And remember, dealing with strict liability, there's no amount of due care on the part of the defendant will relieve them of liability in a strict liability action. So no amount of due care matters, because that's important when you're dealing with negligence, not strict liability. So you want to stay organized. Are they testing me on negligence? Are they testing me on strict liability? I don't choose a strict liability answer if they're testing negligence. I don't choose a negligence answer if they're testing strict liability. Stay organized. I know it's a little overwhelming, but I find helpful making cue cards up and what's called active learning, where you're taking information, bulk volume information, and reducing it down to your own cue cards, and you'll find that's a good way to learn. Then we talked about negligence, we talked about strict liability. Let's talk about another category, intentional torts. Intentional torts. Now, I want you to know that everybody is capable of intent. Incapacity is not a good defense. Therefore, young children and people who are mentally incompetent will be held liable for their intentional torts. Causation is satisfied if the defendant's conduct was a substantial factor in bringing about the injury, because you need some form of causation dealing with intentional torts. Let's talk about the ones that are highly tested. There's battery, tortious battery. There's also criminal battery. And remember, if you bring a cause of action, you're not being tested on criminal battery, you're being tested on tortious battery. So criminal battery is the unlawful application of force to the person of another. That we're not talking about today. We're talking about tortious battery, where you intend to cause harmful offensive contact to the plaintiff's person with intent and causation. So harmful offensive contact. Now, if I walk into an elevator, and example is I'm walking into an elevator and I'm smoking a cigar, and you say, hey, can't you see the sign says there's no smoking here? And I say, and I blow some smoke in your face, how do you like that? Is that offensive to you? And I do it intentionally? Yes. So that's an example of tortious battery. And you have assault. You have tortious assault, which is an act by the defendant creating a reasonable apprehension in the plaintiff. Reasonable apprehension in the plaintiff is tortious assault. Immediate harmful offensive contact to the plaintiff's person, intent, causation, apprehension should not be confused with fear or intimidation. Words alone are not sufficient for assault. Let me repeat that. Words alone are not sufficient for assault. For the defendant to be liable, words must be coupled with conduct. Then you have the intentional tort of false imprisonment. False imprisonment is another popular area tested, and there has to be a sufficient method of confinement or restraint, usually physical force, threats of force, or invalid use of legal authority, is insufficient methods of confinement. The time of confinement is irrelevant on how short the period of time is. A lot of people think it has to be for an hour. a short period of time is sufficient for false imprisonment. There must be no reasonable means of escape known to the plaintiff, part of the requirement. Then you have intentional infliction of emotional distress. Intentional infliction of emotional stress, the key buzzwords are the conduct must be extreme and outrageous. You see those buzzwords, extreme and outrageous? You bring up your definition of intentional infliction of emotional distress. You look for the best of the given alternatives. You do the answers by process of elimination, eliminating things. You get it down to 2, that's not bad. So if you see you doing that at home, that's a good thing. And the more questions you practice, the better you'll get. Practice makes perfect with anything. So I really suggest that if there's 100 questions on the multi-state, I'm talking about the multi-state bar exam, that's given in 41 jurisdictions with the UBE, is that in some states worth 50% of your grade. 50% of your grade. So you have to practice doing what you're going to be called on to do during the exam, which is answer questions, not define a rule for a point. Maybe it's the first year you got a C for defining a rule for a point. Here, you need to know that, and you need to know how to do the test questions also, and you get it down to 2, which one is better. Hopefully, I've been helpful with that. Now, dealing with intentional infliction of emotional distress, the extreme and outrageous conduct is conduct that transcends all boundaries of decency. Unlike other intentional torts, though, recklessness to the effect of the defendant's conduct will satisfy the intent requirement. So recklessness to the effect of the defendant's conduct will satisfy the intent requirement. Then you have nuisance versus trespass to land. Nuisance versus trespass, rather. Now, what do I look for? Physical invasion of the plaintiff's real property. The physical invasion may be by a person or an object. Let's say you take a baseball and you throw it onto someone's property. That's a trespass. Now, odors, on the other hand, intangible matters like odors that enter someone's property, the cause of action would be for a nuisance, not a trespass. So don't be confused between nuisance and trespass. Then you have trespass to chattels versus conversion. And they look similar, but they're different grid spaces on the multi-state as correct answers. Now, trespass to chattel is, let's say you have your BMW parked outside, and I say, oh, BMW, and I take a penknife and I go across it. That's a minor interference with your ownership rights. That would be a trespass to chattel. What is the damage remedy for trespass to chattel? The damage remedy is the cost to repair the car from the scratch on it. It's not the full value of the car. That would be for a conversion. So don't be confused with trespass to chattel versus conversion. Conversion, on the other hand, is where its interference is so serious as to warrant the defendant to pay the full value of the property. Now, let's say an example would be, let's say here in New Jersey, let's say I go to Princeton and I take someone's car and I hotwire it and I drive it to Miami. That's a serious interference with your ownership rights. It's not minor. It's not a trespass to chattel where the cost to repair is the remedy, is the full value of the chattel or the car at the time and place I took it, or the conversion. So let's say the car was worth $6,000 at the time I took it from Princeton and drove it to Florida, and it got damaged for $1,000 on the way there, and then it's only worth $5,000. The damage remedy for conversion is not $5,000, it's the full value of the chattel or car at the time I took the car. So my damage remedy would be $6,000 for a conversion, as opposed to trespass to chattel that's just cost to repair. Another little distinction that I want you to know. Now, at common law, I want you to know this. At common law, the plaintiff may recover damages for the market value at the time of the conversion. At common law, it was called replevin. So don't be confused. You see the word replevin, it's bringing up the same rules that you would for conversion, the same damage remedies. There are some defenses to intentional torts. Now also, you want to choose answers that eliminate elements to what's being tested over defenses. Yes, you learn defenses. Yes, it could be written into an answer choice in tort law, but you want to make sure that you know which one is the best of the given alternatives. Now, so answers that eliminate elements, if you can eliminate an element, you don't have to deal with defenses. So even though a defense might be listed and it is correct as you were taught it, it's not the best answer to the question. You got to practice, I would say, 33 questions a day, because that's the timing of the exam. 33 questions every hour, 100 questions in 3 hours, it comes to 33 questions in an hour. So you want to start timing yourself at home to be done with 16 or 17 questions in a half hour. And I would stay in the same subject so you could pick up these fine line distinctions. And you spend a little bit of time reading over the answer. Don't turn it into a coloring book. Just move along with reading the answers and maybe making a cue card of the rule of law that you got wrong, so you could go back and look at your cue cards and refresh your memory as you're going along with your studying. There are some defenses to intentional torts, like consent. The plaintiff's consent to the defendant's conduct is a defense. Where a person reasonably believes that they're being attacked, they may use force as reasonably necessary to protect against the injury. You have defense of others, defense of property, defense of necessity, and those are all defenses which are good. But if an answer eliminates an element of what's being tested, it's a better response than those defense answers. Okay? Now moving on to what we call another category called other torts, namely defamation, invasion of right to privacy, misrepresentation, claims based on nuisance, and intentional interference with business relations and defenses. Remember, this is only approximately 4 questions out of 200, so not to make a big fuss about it. You do the best you can. That's all a human being can do, is every day you do the best you can. You put the time in. I know that it's a little nerve-wracking and a little bit, am I doing the right thing? You are, just by doing the work, and it will fall into place. And let me point out that just in general, if you get 100, there's 200 questions on the MBE, mixing up 7 subjects, torts being one of them, is that if you get 120 questions correct out of 200, that's 60% of the answers answered correct. 60%. And there's a national scale on the exam, depending how people do on the exam. So let's take an average of 13 points as a scale. So if you get 120 questions correct out of 200, and you get the scale of 13, you end up with a 133 scaled MBE score, and that's used in combination with your MPT and MEE part if you're in a UBE jurisdiction, and that is how it works. Defamation. Talk about defamation. It's language of and concerning the plaintiff. It needs to be published to a third person. It's not enough that it just be said, it has to be published. There needs to be publication by the defendant to a third party, and then damage to the plaintiff's reputation. Now, if you have a public figure involved, defamation motion or a matter of public concern, like dealing with a public figure, the has to prove additional elements of falsity of the defendant's language and fault on the part of the defendant. In a common law case, the plaintiff does not have to prove falsity as part of the prima facie case. Rather, the defendant can offer truth of the statement as a defense. Then you have slander or libel as part of defamation. Slander is spoken defamation. They both start with the letter S, slander spoken, so it's easy to remember. And I would try to use some mnemonic devices to help memorize bulk information that you've been presented over the last couple of months and down the stretch here in July. Now, there's a term called slander per se. With slander per se, the plaintiff must prove special damages unless the defendant falls within the slander per se categories. So the plaintiff must prove special damages unless defamation falls within slander per se. And they are interesting areas. One is deals with a woman's unchastity. One is where there has a Lothan's disease. And one is where they're guilty of a crime involving moral turpitude or adversely affects one's conduct in their business, trade, or profession, are examples of slander per se categories, where the plaintiff must prove special damages unless it falls within one of those 4 categories I just reviewed. The Times versus Sullivan case, I'm sure they reviewed that in school. Actually, I'm not sure of anything, but they probably did cover that. And the public official must prove malice. Malice means reckless disregard of the truth, and that's with a public official. Private people that sue for defamation do not have to show malice. Truth is an absolute defense to defamation, and that's opposed to not defamation, but are they testing invasion of right to privacy? And there's 4 different forms of invasion of right to privacy. Appropriation of the plaintiff's picture or name for the unauthorized use. 2, intrusion upon the plaintiff's affairs or seclusion and solitude. 3 is publication of private facts of the plaintiff in a false light. And public disclosure of private facts about the plaintiff are the 4 forms of invasion of privacy, and you don't get them confused with defamation if you can't help it. Also, in the catch-all category of, 4 questions could be on misrepresentation. Another words for misrepresentation are fraud and deceit. So if you see fraud or deceit in the core of the question, they're testing misrepresentation, and you bring up your definition from bar review to answer it. Okay, that was a good overview of torts. I want, just a 1-hour presentation so you know what cover, how I review things. When you get it down to 2, which is better, an approach that you could stay positive, that all I need on this exam, on the multi-state, is a D. If I couldn't get a D on an exam, I wouldn't have graduated from law school. Why do you say a D, Kenny? Because if I get 60% correct, that's 120 raw score, plus, let's say, arguably 13 as the scale, I end up with a 133 scale combined with my essay portion and MPT part that comes up with the requisite points to pass the bar exam. And that is, you're not to think I need to know every nook and cranny. I need to know every rule. I got an A on this class. You got an A maybe because 300 or 400 pages were covered in 4 months. This is covering an entire hornbook and restatement. So I want you to be gentle on yourself, easy on yourself. I want you to take breaks. I don't want you to sit for 4 or 5 hours, 6 hours at a time so you start levitating off the chair. But makes perfect, whether it be for multiple choice or essay, in particular multiple choice, because the multi-state is a fair exam, but it's very sophisticated, and you have to have an approach coming into it. And you'll see people that are successful in it have done 700 to 1,000 practice questions prior to the bar exam. And if you haven't started, now's the time to get started doing questions and understanding when I get it down to 2, which one is better, how to approach the exam. I want to wish everybody the best of luck. I know you're going to do well. I fear of the unknown, fear of the exam, and you're right people. You wouldn't have got into law school, you wouldn't have gotten through it. And I have all the confidence in the world in you that you're going to pass this exam and become successful lawyers, and will make some changes in this world that's needed. Thank you for your time today, and best of luck to you. Bye now.